This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why the failure of a lawyer to report a claim to his insurer is fatal to his coverage under a claims-made policy, which may never respond to a claim made after expiration of the policy. Twin City Fire Insurance Company sold a malpractice insurance policy to John S. Xydakis, an attorney and one of the defendants. Xydakis made claims under the policy based on lawsuits and motions filed against him in Illinois State Court. Twin City sought a declaratory judgment that it owes no insurance coverage to the defendants for these claims, or in the alternative for rescission of the policy. In Twin City Fire versus Law Office of John S. Xydakis, P.C. et al., a decision of the United States District Court for the Northern District of Illinois, Eastern Division, on March 20, 2023, the United States District Court resolved the dispute. In the affidavit to which Xydakis objected, Twin Cities counsel averred that several publicly filed documents were either served on Twin City or retrieved from the Cook County Clerk of Court or the Illinois Appellate Court, and they failed because the court could take judicial notice of publicly filed documents in other courts, if, as in this case, their existence was not subject to reasonable dispute. There were three lawsuits that were the subject of the claim made by Xydakis. First, the Chen Lawsuit, where Fiona Chen Consulting Company sued Xydakis for failing to pay retained expert witness fees. Xydakis filed a sworn answer, affirmative defenses, and a counterclaim against Chen Consulting, demonstrating that all of the acts and conduct related to the Chen lawsuit occurred between January 2012 and November of 2012. Then there was the Spiegel motions for sanctions, where litigants in a separate set of lawsuits brought three motions for sanctions. The presiding Cook County judge ruled on all three motions and entered judgment against Spiegel and Xydakis for over $1 million. Then there was the Klein lawsuit. On August 14, 2019, Tiberiu Klein filed a complaint against Twin City and Xydakis alleging legal malpractice, breach of contract, and breach of fiduciary duty. The Klein lawsuit alleges that Xydakis' wrongful conduct caused Klein to lose his statutory deadlines and his opportunity to collect a significant recovery of settlement proceeds in an underlying 2014 tort lawsuit. The Klein lawsuit alleges Xydakis knew of his malpractice on March 9, 2018, after the Seventh Circuit Court of Appeal issued a damning decision criticizing Xydakis for his various failures in representing Klein, which amounted to legal malpractice. Now, the Twin City insurance policy was issued in December of 2016 after Xydakis applied for legal malpractice insurance from Twin City. Twin City underwrote and issued a claims-made and reported lawyer's professional liability policy to the law office of John S. Xydakis. Xydakis sought coverage from Twin City for liability in the Chen lawsuit and for the Spiegel motions for sanctions. Twin City denied it owed Xydakis defense or indemnity obligations in those matters. Additionally, the Klein lawsuit sought damages in connection with Xydakis' alleged malpractice, and Twin City likewise denied it owed defense or indemnity obligations for the Klein lawsuit. Under Illinois law, An insurer's duty to defend arises when the facts alleged in the underlying complaint fall within or potentially within the policy's provisions. The insured bears the burden of proving that its claim falls within the policy coverage. Once the insured has established coverage, the burden shifts to the insurer to prove that a limitation or exclusion applies. Claims-made insurance policies protect only against the risk of an injured party bringing a claim against the insured during the covered period. Xydakis entered into a claims-made policy with Twin City that began on January 26, 2017, and specified that January 26, 2016 was the retroactive date. By its plain language, the policy covers only damages arising from Xydakis' acts or omissions that occurred on or after January 26, 2016. The policy ended on January 26, 2018, and was not renewed. It allowed up to 60 calendar days after termination to report a claim. So Xydakis had until March 27, 2018 to make claims under the policy. The Chen Lawsuit, the Spiegel motions for sanctions, and the Klein Lawsuit all fall outside the policy's scope of coverage, either for underlying conduct occurring before its retroactive date or for claims made after its expiration. Xydakis, hoping to get around the problem with the dates of coverage, argued that estoppel was available to create a genuine issue of material fact as to whether Twin Cities should be estopped from denying coverage. The court concluded it does not, because estoppel only applies where the insurer has breached its duty to defend. When the policy and the underlying complaint are compared, there was clearly no coverage or potential for coverage, and therefore estoppel cannot apply. Estoppel may never be used to create or extend coverage where none exists. Where no duty to defend exists, and the facts alleged do not even fall potentially within the insurance coverage, such facts alleged could obviously never actually fall within the scope of coverage. Under no scenario could a duty to indemnify arise. Twin City owed defendants no duty to defend in any of the underlying actions, and therefore no duty to indemnify existed. The court therefore granted Twin City's motion for summary judgment and declared that Twin City owed no duty to defend or indemnify Xydakis under all his professional and individual forms. In my opinion, a lawyer should know how to read an insurance policy. Since a claims-made and reported policy requires that there is only coverage if the claim is made during the policy period and reported within the policy period, Xydakis' failure to report the existence of the claims during the policy period, so that there was neither a duty to defend nor a duty to indemnify, resulted from his own negligence and failure to deal with his policy. In addition, he apparently concealed the fact of the litigation in the Chen lawsuit against him that predated the inception of the policy. Xydakis, in my opinion, is properly out of business and is no longer practicing law and must pay any judgment against him from his own assets. This video was adapted from my blog Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. If you subscribe to the blog, you will be advised of every blog posting, usually 5 a week, and that given access to the more than 4,450 blog posts presently online. You can also view these videos at rumble.com and youtube.com and can subscribe to them at no cost. And if you found these videos to be useful or appropriate, please tell your friends and colleagues so that they can also subscribe. And you might also wish to consider subscribing for a very small fee to my locals community and my Substack publications for additional information about insurance claims, insurance coverage, and how to deal with insurance matters. Thank you for your attention.